Hello everyone, it's Sade here. Welcome back to our video updates. Today's video is going to discuss the subject to agreements or subject to deeds. And this particular instrument can be used in the state of Texas. I'm not sure about all the other states, so check with your local lawyers to see if this is possible. It's a very creative and sophisticated tool that's used by investors to get ahead whenever they're doing different deals. So it's just a way of structuring a real estate deal so that the investor is able to approach the property owner and work something out that's not the traditional buy-sell agreement or the traditional assumption. So this particular type of deal is called subject to because we can differentiate between the debt obligation and the title to property, because when you're talking about a deed, the deed is the instrument that shows ownership of the title, and then the debt obligation could be something like a loan, home equity loan, or mortgage, or a regular mortgage loan. The first thing to know is that the debt obligation is separate from the title itself. So when people are talking about the subject to, they're talking about taking title to property without assuming the debt obligation. So when you're talking about a note, which is the promissory note or the mortgage, that's talking about the debt itself. And then the deed is that document that conveys title. So those are the things to keep in mind. So subject to means that the investor is stepping in and taking title to that property, but not promising to assume the debt if there is a mortgage. And typically this only works when there's a mortgage. Otherwise the homeowner wouldn't need an investor to step in. So let me give you a scenario under which it typically happens. Maybe the homeowner had a lot of medical bills or some financial change that is causing them to fall behind on the mortgage payments. The investors, they tend to get a pre-foreclosure list, which tells them which properties are distressed or in trouble. And so they would approach the homeowner who is not yet in full-blown foreclosure, obviously, and then offer the homeowner an opportunity. And typically they'll ask the homeowner if the owner is willing to transfer title to that investor, and then the investor can take the property, work on it, possibly repair it, fix it up, upgrade it, and then sell it. And then when it's sold, the investor would get the profits from that sale. But in order to get title to that property, the investor would pay the homeowner typically just the equity that's in the home, or a little bit less than that. And the benefit to the homeowner is that the person does not go through full-blown foreclosure, so there's no foreclosure on their record. And then also they can walk away without the hassle of trying to sell the property themselves. Possibly it's not in good shape, so it would not sell well to begin with. And then they also get the benefit of having somebody else pay them right away, cash. It's a cash out because of the equity that's in the home. And so they walk away, and then they still have that debt obligation in the background, which is the thing that's important with the subject to, because the investor is not promising to pay that debt usually. They do take subject to that debt. So that means that after the investor fixes it up and flips it, sells it, then the investor pays off the debt obligation as well as takes the profit. So that's how the subject to works in pure form. But some people do a hybrid of it where it's sort of like a joint venture. So let's say that property is currently valued at $100,000 because it has some damages that could be fixed or have to be fixed before it can be sold for a reasonable price, and the homeowner is behind on the payments. So it's worth $100,000. The homeowner is behind on the payments about $10,000 worth. But currently the mortgage loan on the property is only $60,000. So the property is worth a little bit more than what the mortgage is on there. But the homeowner knows that if they place it on the market right now, it's only going to sell for about $100,000 because they didn't do the repairs needed, and that's because they don't have money to do the repairs. So the homeowner is approached by an investor that promises to do the repairs and then sell the property once the repairs are done. and then the homeowner is paid either right now in order to sign over that deed to the investor so they could get paid the equity. The current equity in there is only $40,000 if we're doing straight math. That's because the property is worth only 100 right now in the shape it's in, and the loan balance is 60,000. So the investor could give the homeowner 40,000 and say that's all that the equity that's in there, and I also promise to catch up on the $10,000 back owed amount on the mortgage payments that you've missed. The homeowner might agree to that. Some homeowners would say, well, I know that once you fix it up, this property is going to be worth $200,000. So I would like an opportunity to split the profits with you. And for doing so, all you have to give me right now is just the $10,000 to catch up on the payments, and then we both can split the profits once you make a profit in the future. So some homeowners would do that because when you do the math on that, the $200,000 that it will be worth after the repairs, once you deduct all the costs to the investor, it is possible that the profits that they make on that house, once all the repairs are done, is going to be a lot of, let's say they made $20,000 worth of repairs. And so the $20,000 worth of repairs plus the $60,000 that's owed to the lender, that the investor does have to pay that off. So that's $80,000. And then that property is now worth $200,000. So you can see that there's a profit margin of $120,000 for that investor. So the homeowner that's savvy would negotiate to split the profits rather than to allow the investor a straight up subject to agreement where the investor takes all of the profit and pays them equity up front. So some homeowners would take all the equity out right there, and some would say, I would like to split the profits with you. That's more of a joint venture, but it's also still a subject to, because the investor is not making any promises to make payments on the mortgage in the meantime. It's going to be a quick fix and flip arrangement. And sometimes the investors actually don't even fix and flip it. They just sell that contract to another investor to do the work. And then that other investor steps into the shoes of the first investor. So inside the contract, it would say that the contract is assignable. The only thing that's recorded in the property record should be the deed itself. And it should not have confidential details. In my opinion, it should really not have all the terms. You should have a separate agreement that shows all the terms of the subject to arrangement. So it could be a joint venture agreement that you have if you're splitting the profits with the investor, or it could be if the investor and the homeowner are splitting the profits, it'll be a joint venture agreement in conjunction with the subject to agreement. So what lawyers do is they design a specific contract for that particular deal. We do use the forms that are promulgated by the board, the Association of Realtors here, and then we do an addendum that has all the subject to language in there to make sure that whoever we're representing is protected, right? Of course, we want to make sure it's a fair deal, but the negotiation is up to the parties. And so the lawyers will just make suggestions, and then you go in and negotiate that deal. The other way that the investor could use a subject to agreement and contract is to actually step in, do a little bit of repair, and then owner finance. But that's more of a long-term strategy. So you step in, take title to the property without taking on the debt obligation, and then you get a different person that's willing to purchase that property, and then you mark it up, of course, by charging interest and getting a down payment from that new party, and then you hold the note and allow them to pay you slowly. And when they pay you slowly, it's slower to get the money out, so it's a longer term investment strategy. The fix and flip is more common, and it tends to be very lucrative in a market that's a hot market. If you have property that's all that's needed is just major fixes, but they can be done quickly. Maybe the roof needed to be repaired and there's no longer any insurance coverage on there. Maybe the floors needed to be redone and just upgrade the appliances, and the homeowner simply just doesn't have the money for that. So the investors will do those fixes and then do all the cosmetic fixes. It will make the house really appealing to the public once it's listed for sale. So that's a good way to get in without having to assume the debt obligation itself. Especially as a short-term strategy, it works really well, in my opinion. So, but when you're doing this, please do not use any documents that you're finding online, because those are not going to protect all your interests, whether you're the seller or the buyer. So just make sure that you have a lawyer involved and they're helping you with this deal. In Texas, there's supposed to be a 7-day window in which the parties can cancel the agreement. You do have to send notice to the buyer, in this case the investor, and the investor has a right to cancel that agreement within 7 days. But because the investors are the ones that are making money from this, they don't typically want to cancel it unless maybe they find a different, better deal, and then they need to cancel. So there's that time frame before you can close on the transaction. So 7 days from the date of the contract before you can close on the deal. And also, you're supposed to send the notice to the lender, but most people don't do it. And it's in real life, in practical sense, it doesn't really make any difference. The lenders ignore the notices most times anyway. So it doesn't really matter. There's no harm in that. The due up on sale clauses that are inside the original deed that the homeowner has with the lender, though it's not considered a breach, it's just an optional right that the lender has to demand that the whole loan is due right away. And the lenders don't do anything. From my experience, I haven't seen them do anything when people do these deals. The lenders pretty much tend to look the other way as long as they're not yet in full-blown foreclosure, or as long as the back owed payments are caught up. The investors that are pretty savvy, they know that they would catch up on the back owed payments. So that's part of the consideration of entering into this kind of deal with the homeowner. So hopefully this has been helpful to you. I know we get a lot of different questions. It's not as easy to explain this particular one because it's just dependent on the parties, what they negotiate. But I think this video will give you an idea what it looks like, and there's specific language that the lawyers have to put inside the deeds in order to make sure that the investor is clearly not assuming the debt obligation. Of course, the agreement would explain, not the one that's recorded, not the deed, but the agreement that you have, which is the contract, would explain that the investor is paying the back owed mortgage payments only, and then not assuming the actual loan, but just taking the property subject to the mortgage that's already there. And that just basically means that they'll pay it off once they resell that property or refinance that property. And the other thing that I think is important to know is that do not allow anybody to give you a quitclaim deed for this type of transaction. Don't allow the homeowner to give you a quitclaim deed, because those don't tend to work in Texas. The title companies don't like to insure title when there's a quitclaim deed in the chain of title. So you might run into trouble in the future. And when your lawyer is putting together this contract for the subject to, make sure that there's a power of attorney included in there to allow you as the investor to talk to the lender directly, because once you've fixed up that property and you're ready to flip and you find a buyer to buy it, you need the payoff amount. And the only way that you can get that information from the lender is if you have power of attorney, or if you have the online login information to that account, the loan account. So you can get all of that written inside the contract to make sure that you don't have to be chasing the homeowner down in the future when you're ready to pay off the loan. So those are my tips for you on that. Educational purposes only, of course. Anytime you have questions, you have to check with a lawyer in your area, and they'll be able to help you. So thanks for watching as always, and I'll talk to you next time.